President immune if he uses SEAL Team 6 to kill a political opponent?
Senator,
yes or no?
With respect,
okay.
I think the Supreme
With respect,
Court...
you're not willing to answer the question. Let me ask you a different question. It was recently reported that the president and his family made around $6 billion from the sale of crypto assets. Some of that money, much of that money, comes from the Gulf. If the president were to sell a foreign policy decision to a Gulf nation in exchange for a crypto donation, is he immune from prosecution for that?
Senator, I don't know anything about the situation that you are describing.
But you know something about the immunity decision. You said it was modest. Chair, Professor, you've appeared before the committee many times, but the last time you were in committee was for a hearing entitled, "When the President Does It, That Means It's Not Illegal, the Supreme Court's Unprecedented Immunity Decision." At the time, you described that immunity decision as modest, and I want to ask you about the modest impact of that decision. When John Sauer was here for his confirmation hearing, I asked him about an argument he made in that case before the Court of Appeals, in which he was asked specifically by the Court of Appeals judge, one of them, if the president were to order SEAL Team 6 to assassinate a political opponent, would he be immune? His answer apparently was yes, unless the president's party was willing to impeach him first. Is that your view as well? Would he be immune from prosecution for using the military to assassinate a political opponent?
Well, Senator, as a lower court judge, I'd be fully bound by Supreme Court precedent. On that particular question, and this is one reason I address the opinion as modest, the opinion addresses only portions of presidential immunity. It specifically is addressing criminal immunity.
I asked you a specific question. Would the president be immune from prosecution if he ordered SEAL Team 6 to assassinate a political opponent? No.
Senator, under the Supreme Court precedent on that question, the Supreme Court has specifically not answered it.
Is that a difficult question? Is that an open question in your view?
Well, Senator, under the contours of Trump versus United States, which deals with criminal immunity, I'm not sure that it fully answers all of the political mechanisms that would be in place to address and keep such a horrific situation from ever occurring.
So you're unclear as to whether a president could be prosecuted for that. Is that what you're saying? You don't know the answer?
Well, I think what I'm saying is that within the particular contours of criminal immunity discussed in that opinion, it addresses actually what is an official act. And so I think the first threshold question would be whether one could ever conceive of such a thing as an unofficial act.
I don't want to filibuster my question. It's very simple. If the president tomorrow to order SEAL Team 6 to assassinate a political opponent, in your view, is he immune from criminal prosecution absent an impeachment first?
If it's not an official act, a phrase that has not yet been fully defined,
if he's using the military to do it, which the court said he has absolute immunity when he deploys the military, is he immune or not?
Well, I don't read the court's decision to say that any use of the military outside of official acts comes within its immunity contours. And as this body knows, because of various drone strikes and other things.
So under the question I asked you, what's the answer, Professor? Yes or no? You're used to answering questions and asking your student questions. I'm asking you a very simple question. Yes or no is the question. Yes or no, is the president immune if he uses SEAL Team 6 to kill a political opponent?
Senator,
yes or no?
With respect,
okay.
I think the Supreme Court...
With respect, you're not willing to answer the question. Let me ask you a different question. It was recently reported that the president and his family made around $6 billion from the sale of crypto assets. Some of that money, much of that money, comes from the Gulf. If the president were to sell a foreign policy decision to a Gulf nation in exchange for a crypto donation, is he immune from prosecution for that?
Senator, I don't know anything about the situation that you are describing.
But you know something about the immunity decision. You said it was modest. I'm trying to determine just how modest you think it is. Can the president sell U.S. foreign policy to the highest crypto donor and have a get-out-of-jail-free card?
Senator,
or is he liable for prosecution?
Senator, if I may, the Constitution has many constraints for all of us.
You don't want to answer that question. Let me ask you a very different question. If the president were to use the military in direct violation of court order deliberately, knowingly, blatantly used the military in violation of court order, is he immune from any liability?
Senator, as I said when I testified last September about the decision, the Clinton administration had an opinion.
I'm not asking about the Clinton administration.
But it's directly relevant, that a president, the position of the Clinton administration is that a president,
I'm not asking
while
the position of the Clinton administration, I'm asking your position, your view of the immunity decision, which you've described as modest. I'm trying to determine just how modest you think it is. You're unwilling to say a president can't kill an opponent and be liable. You're unwilling to say the president can't sell foreign policy of the United States for cryptocurrency. You're unwilling to say he can't do that and still be immune. My question is, can he use the military in deliberate violation of court order and be immune, yes or no?
Senator, you're asking very specific questions about whether our criminal justice system is the
Madam
forum
Chair,
to punish.
I yield back.
You should never have to ask whether a president can order an elite military unit to kill a political rival and get away with it. Yet, here we are. In this hearing, Adam Schiff forces that question into the open because the Supreme Court's new approach to presidential immunity has created a fog where there should be bright lines. The nominee's refusal to give a simple yes or no isn't just frustrating, it's the point. Ambiguity at this level is an invitation to abuse. Here's what changed, in plain English. For decades, we had two bookends. Presidents are absolutely immune from civil lawsuits over official acts, Nixon v. Fitzgerald, and not immune for private conduct, Clinton v. Jones. The new decision on criminal immunity slices the world into official acts and unofficial acts for criminal law, too. Core constitutional functions get the strongest protection, and a wider halo of official actions gets presumptive protection. What's official? That's exactly the gray zone Schiff is probing, because once you're inside that zone, accountability gets murky fast. Schiff's hypotheticals aren't stunts, they are stress tests of the system. Start with the most shocking one, ordering SEAL Team 6 to assassinate a political opponent. Under any normal rule of law analysis, that's illegal on multiple fronts. Murder statutes don't disappear because the commander-in-chief gives the order. The military has a duty to refuse unlawful orders under the Uniform Code of Military Justice. Executive orders prohibit assassination. The posse comitatus tradition sharply limits domestic military force. But the reason this hypothetical matters is the official act trapdoor. If an order is argued to be part of the president's command authority, defense lawyers will try to drag it into the official bucket and then argue immunity, or at least argue that prosecutors can't even use the president's official order as evidence of the crime. That's the danger of ambiguity. Conduct everyone recognizes as criminal gets laundered through the language of office. Second, selling U.S. foreign policy for crypto. Strip away the tech buzzwords, and it's as old as politics: bribery. Federal law criminalizes bribery of public officials. The Constitution literally names bribery as an impeachable offense. Add campaign finance bans on foreign money, and you're stacking felonies. The challenge post-immunity decision is evidentiary. If the official act is, say, a policy announcement or a diplomatic decision, can prosecutors use that act to prove the quid pro quo? If the answer is no, you've made bribery by a president harder to prosecute precisely when the stakes are highest. Third, using the military in defiance of a court order. Our constitutional system depends on each branch respecting the others. Courts can tell a president no. History backs that up. When Truman tried to seize the steel mills during war, the court shut it down. If a president uses force to overrule the judiciary, that's a full-blown constitutional crisis. Again, the immunity puzzle appears. Is defying a court via military deployment an official act? If so, do criminal penalties vanish unless Congress impeaches first? If the legal answer is, we're not sure, the practical answer is, that's a road autocracies travel. Why didn't the nominee answer directly? Partly because lower court judges are bound by Supreme Court precedent and avoid prejudging issues. But the refusal also exposes the real-world risk. If the people who will interpret these rules can't say out loud that murder, bribery, and defying courts are prosecutable, deterrence weakens. Powerful actors hear that hesitation. Let's ground this in human terms. A president who can deploy force against rivals chills protest, journalism, and basic political participation. Communities that have fled strongman politics hear these hypotheticals and don't think law school exam. They think Tuesday. The rule of law isn't an abstraction. It's the difference between citizens and subjects. Guardrails still exist, but they need reinforcement. The military's duty to refuse unlawful orders is real. So are inspectors general, career prosecutors, whistleblower channels, and state attorneys general. Congress can strengthen them. It can clarify by statute that certain crimes, bribery, obstruction, witness tampering, using armed forces domestically in violation of law, are never official acts for immunity purposes. It can make explicit that official acts may be used as evidence of criminal intent. It can harden protections for military and civilian personnel who refuse unlawful directives. It can require transparent logs of presidential directives and emergency actions with preservation rules that prevent convenient gaps in the record. And yes, it can use the power of the purse to condition executive branch funds on compliance with court orders. Most importantly, Congress can legislate bright lines now, before the next crisis, because ambiguity is not neutral. It favors the most aggressive actor in the room. If we wait to fix the rules until after the line is crossed, accountability turns into a political coin flip. Here's the takeaway. Schiff's questions are a referendum on whether we still mean it when we say no one is above the law. If your answer is yes, then the reforms can't be optional. They have to be codified, testable, and enforceable regardless of party or president. If you want this show to keep turning legal fog into plain language and pushing for real guardrails, here's what to do next. Subscribe and turn on notifications so you don't miss the follow-ups. Share this with someone who thinks the new immunity framework is modest, and ask them which of these hypotheticals they're willing to leave unanswered. And call your senators to support legislation that clearly excludes crimes like bribery, obstruction, and unlawful uses of force from any immunity claim, and allows official acts to be used as evidence of criminal intent. Then tell us in the comments which reforms should be first on the docket: clarifying the definition of official acts, tightening anti-bribery rules for the presidency, or strengthening whistleblower protections. Democracy doesn't defend itself. People do.